Hello, everybody. Hello, C-Rex. I hope you made it. Hello, Nana Laura. Hello, She's a Maker. Hello, Sir Philip. Hello, Shane. Hello, CE. Hello, Barbie. Hello, Lyndall Applegate. I had a toss-up of continue to try to find content and edit it or jump in the shower. Shower one. I'm having my usual wet hair before stream emergency. Hello, Chinny. So I hope this case is good. I kind of quick ran through it because every time I stopped for even 2 seconds, the judge and the lawyer were going at it. Very grumpily. Hello, Spider-Man. So happy you're here. Hello, Colette McCoy. So from what I was able to glean from the case, it is a motion for summary judgment. Someone is suing Home Depot. They fell in the store and they're claiming it's Home Depot's fault. And of course, Home Depot's lawyer is arguing no. So that's what we get to watch tonight. And I really hope that you guys enjoy it. Come on, computer. Hi, Sherry B. Give me just 1 second, sweetie. I'm having serious computer troubles at the moment. Okay, here we go. I think I've got it now. Forgive me, please. Pretty, please.
Thank you for waiting, Your Honor. We are on the record.
All right. Good morning. This is the matter of, I lost my place. Sherwinski versus the Home Depot, FBT CV 22-611-3154. Will the participants please identify yourselves?
For the plaintiff, Stuart Casper.
For the defendant, Home Depot USA, Inc., Caroline Labush.
All right. This is the defendant's motion for summary judgment. I have reviewed the submissions of the parties, at least sufficiently to familiarize myself with the issues as being presented. So without further ado, I will let defendant's counsel explain to me what needs to be emphasized, clarified, rebutted in terms of the plaintiff's arguments or anything else you think are noteworthy, or however you wish to otherwise present the motion to me.
Thank you, Your Honor. We're here, as you know, in Home Depot's motion for summary judgment that is brought on grounds that there's no genuine issue as to any material fact that the plaintiff cannot prove what caused him to trip and fall. As you're aware, Your Honor, Practice Book 17-49 states that summary judgment shall enter if there's no proof if there is proof of no genuine issue of material fact as to an essential element of plaintiff's claim. In this lawsuit, Mr. Sherinsky claims in paragraph 6 of the complaint that he was shopping at Home Depot's Trumbull store on July 3rd, 2020, when he tripped over an unsecured wire attached to one end of an orange dolly. And that orange dolly is pictured in MSJ exhibit C. He has asserted a negligence claim, and of course his wife has asserted a loss of consortium claim. To prevail, the plaintiff has to prove each of the 4 elements of his claim: duty, breach, causation, and damages. In this case, it is undisputed. The plaintiff has not disputed the fact that he has no memory of what caused him to fall. He said he's used terms like, I must have backed up. I didn't know what it was until I was lying there. He assumed that he caught his foot on a wire after he looked up.
Well, let me look, if I may interrupt you there, let me just ask a generic question. In what colloquially are referred to as trip and fall or slip and fall, whether it's on ice or a puddle of water in a supermarket or a raised slab of concrete or whatever it is, isn't it usually the case that the person doesn't know what happened until after it happens, and then the person says, oh, it must have been, because the person may not be conscious of it as it's happening? I mean, isn't it almost routine for it to be sort of a retrospective of, I didn't see it, I fell, oh, it must have been the ice, it must have been this puddle of water, it must have been this raised lip on the carpet or on the pavement or whatever it is? Isn't that kind of a routine kind of starting point for lawsuits involving, again, slip and fall, trip and fall kinds of premises liability cases?
A starting place, yes, but we're now 2 years into the litigation, and the plaintiff has retained an expert that he has paid to testify as to causation, and he not once mentions to the expert that I, in fact, caught my left foot or my right foot on something, after which I determined it was the wire that I saw after the fact. He couldn't tell me during his deposition which foot became, all he remembers was being in a standing position and then being on the ground. And Home Depot has cited 3 different summary judgment cases in which the plaintiff had exactly what Your Honor referred to, which was some kind of something caused the person to trip and fall. In Oglesby, the plaintiff tripped and fell on a sidewalk. She could not identify what caused the trip and fall. Summary judgment was granted in favor of the defendant. In Kubera, which I think is a very similar lawsuit to this one, the plaintiff walked into a bookstore that was described as being in disarray, with books all over the place, and a potential defect in the carpeting and or the tile. The plaintiff came around the corner, couldn't say what caused the trip or fall, and summary judgment was granted for the defendant because the plaintiff said, I don't know what caused me to trip and fall. In De Oliveira, which is an even more stark example of just how far the court will go, an appellate court upheld an entry for summary judgment where the plaintiff was doing work on a porch and the safety railing failed somehow, and the plaintiff fell and could not identify specifically what caused him to fall, even though the safety railing undisputedly failed.
But isn't that actually very far away from this case? Because that's a structural failure situation where the court said, well, we don't know, did it fail because it was rotted? Did it fail because too much force was applied? That is a different kind of thing than there's a condition that somebody encounters and I don't know why I fell. Oh, I look around and I see a wire, I see a puddle of water, I see ice or snow. That was a question of what caused that particular structure to fail at that moment. That's a very different kind of premises liability case as far as I'm concerned.
But it was still a failure in terms of the premises owner. And that was the allegation, was that the premises owner was somehow negligent in maintaining or erecting or otherwise handling its premises. The other 2 cases, like I said, Your Honor, were cases where there was exactly what you just described. Someone tripped and fell, and they said, oh, it must have been the sidewalk. Well, they couldn't identify what caused the trip and fall. And in Kubera, again, the bookstore, which was in disarray. Just the fact that the plaintiff happened to fall in Home Depot's store does not warrant the presumption that Home Depot caused the fall and was therefore negligent. The plaintiff said to his own expert, I stepped back to get a piece I didn't need anymore. The next thing I knew, I was on my ass. And that is a quote from the plaintiff telling his own expert, who he has every reason to tell exactly what happened because he is paying him as a medical expert on the issue of damages. The plaintiff's own affidavit submitted in favor of his case in opposition to the summary judgment motion doesn't say, I do remember how I tripped and fell. He admits he doesn't. He says, the only thing that that can explain what caused this to happen was this wire dangling from the pallet nearby. This is not any, the cases that the plaintiff cites are in no way similar to what the plaintiff is asking the court to do here, which is you look at a dangling wire and that we're entitled to infer that there was some negligence or infer that this is what caused him to fall. The only cases that the plaintiff's counsel has cited are a series of staircase cases where someone has fallen down a staircase and in tandem with some other defect, such as the lights are off, the doorway to the person who fell down the staircase's bedroom was at the top of the staircase, or there's a defect in the staircase. Those are obvious res ipsa type observations. A staircase is an obvious danger to any person, whereas a dangling wire like the plaintiff.
Excuse me, a staircase is an obvious dangerous condition?
A staircase is something that if someone is found at the bottom of a staircase, it is fair to understand how they got to the bottom of the staircase, especially where there are other.
No, that's the problem I have. You see, I'm even before plaintiff's counsel filed his brief, I was aware of these staircase cases, and basically the court says you look at the circumstances around the situation, because you're almost positing a situation where if you have amnesia or somebody dies in a situation like this, the person can't testify, therefore you're saying there is no possible liability. And the cases say if the person doesn't testify, you still can look at the circumstance. So if somebody looks around and says, this is the only condition, I mean, I already knew that there was cases out there about the staircases. Those cases take a look at the global situation. A staircase is not negligence. You need to have something more. And just because the light is burned out doesn't mean it caused it, but the courts allow people to think about what could have caused it based on known circumstances surrounding finding a body at the bottom of the stairs. Nobody is in a position to say it was that condition.
I understand that, and that's not what the courts found, Your Honor, which is exactly what I'm trying to say. It sounds to me as though you're very familiar with these staircase cases, so I don't need to tell you that these were cases where the staircase was one aspect of the case. There was also evidence in every single one of them that there was some other issue at play. For example, uneven treads, a lack of a safety railing, a defective safety railing, lack of proper lighting, a precariously positioned doorway where they had prior falls, and there was specific inquiry about the location of the stairwell in connection with where the person was going to reside. No, plaintiff has not cited a single premises case that has occurred in a store that is at all similar to this. Home Depot has. We've cited 3 different cases, one of which I think is directly on point, which I've emphasized previously, which is the Kubera matter, which is the bookstore case. If the plaintiff cannot identify what caused him to trip and fall, and does not remember even tripping over anything. He doesn't even say he tripped. He says, I remember being on my feet and then I'm on the ground and I'm lying there and the only thing I look at, it must have been that. Well, that's not enough. The plaintiff has to prove by preponderance of the evidence each of the elements of his claim. And the courts in Connecticut have been clear on this fact, that summary judgment should be granted where the plaintiff doesn't know what caused them to fall, especially where there are no witnesses who can corroborate what occurred. Summary judgment was granted in Kubera, summary judgment was granted in Oglesby, and summary judgment was upheld in De Oliveira on the same grounds. Hall v. Winfrey was one of the staircase cases cited by the plaintiff, where the defendant testified the hallway was unlit on the day of the incident. And the hospital records indicated that the plaintiff fell down a flight of stairs. The plaintiff heard the decedent tumble down the stairs and testified about the same. that was not dispositive of the case, but it did permit an inference as to what possibly could have caused this injury. Blados is another case where the person was found lying at the base of a staircase, arms outstretched. The medical examiner opined that he had fallen down a staircase. And in the dissent even, in allowing the inference to proceed, the dissent said it is incumbent on the plaintiff to establish that a defective condition on the stairs was a proximate cause of her decedent's injury and death, especially when no one saw the person fall down the stairs. Facey versus Merkel, the defendant was witness to the plaintiff rolling down the last couple of steps, and he was unable to speak to any extent about what caused him to trip and fall. And in that case, the plaintiff was allowed to make that was the case, I believe, where the plaintiff had specifically warned that there were other concerns about this particular staircase vis-a-vis the location to the bedroom. In Dickinson v. Yale, the plaintiff, there was a balcony that was in a dangerous condition, which was an undisputed fact. There was a non-compliant railing in violation of the safety code. And the decision on appeal from a grant of a motion to set aside the verdict, the jury found that defendant was a proximate cause of the injury. That case, again, is not just a staircase. We're dealing with a violation of a safety railing that was not to code, etc. In White v. Herbst, which is another case cited by plaintiff's counsel, the plaintiff produced evidence of other people falling down that very staircase. So there was an issue of notice. And in Augustine,
what was the defect? What was the defect that was found in White v. Herbst that was found to be the defect? Because that White v. Herbst is the case that I sort of bookmarked for myself as a somewhat extreme kind of situation where the court declined to say that the lack of direct evidence was going to be fatal to a claim of, gee, the stairway somehow caused the negligence in the premises liability caused the death of the decedent.
Well, I don't think that in White v. Herbst, there was, the stairway was unlighted. The handrail and the steps were this is in the court's opinion, in a very defective condition. There were 15 risers. The first 3 from the bottom were 9 1/2 inches high, and the others were 8 1/4 inches high. The treads were badly worn, and the nosings were broken. And
she's talking about a different case that she's citing the case law of. This gentleman fell because there was a wire hanging off the back of a dolly that his foot got caught on and tripped him. Has nothing to do with stairs. It's imagination.
Other people had fallen down the stairs. And this is not the same scenario that we're dealing with in this case. In this case, we're dealing with someone who admits that he does not remember what happened. He told his own expert he doesn't remember what happened. He told me he doesn't remember what happened. That is not sufficient for a fact. If plaintiff gets on the stand and says, and I cross-examine him both on the 2 pieces of evidence that plaintiff's counsel wishes for the court to use and to overlook the hearsay rules and to accept as for the truth of the matter asserted, the police report and the incident report, those statements were taken from the plaintiff. When I asked the plaintiff about the statements, how did you fall? Which foot caught? How did this happen? He couldn't remember. He says, I don't remember. It must have been this. It should have been that. I assume it was this. That's not enough under Connecticut law. And the plaintiff wants to play a game of semantics where he should have chosen a different. He had every opportunity to tell me that my left foot caught on this wire right there in that picture, and that's how I fell. Or I know I fell and it was this foot or that foot. He couldn't tell me anything. He says, I don't remember. He said, it's kind of like, I guess, but I don't remember. But all I remember is hitting my butt, and I remember the shock. I remember going back. That is not saying I tripped over this item in the store, and this is what caused me to trip and fall. You know, Home Depot is entitled to defend a case based on a known defect. He has identified a defect that was based on photographs and pictures taken after the fact. That is not the same thing as identifying a defect based on what actually happened. The plaintiff has to prove what caused him to fall. This is not a case where you can say, the jury should hear this lawsuit because there's a staircase that's unlit with a broken railing and a person at the bottom of the staircase. That's not this case. The plaintiff hasn't cited any case that's at all similar to this one. And Connecticut courts have already agreed with Home Depot's position on this. If there is no evidence that a particular defect caused the incident, and there can be none at this point. The plaintiff has already had his deposition. We've been in years of litigation on this point. The plaintiff has a post-summary judgment, and the best he could come up with was in his opposition. He said, well, basically, the only thing near me that could have caused this was this particular wire that I saw pictured after the fact. That's just not enough under Connecticut law. The plaintiff wants the court to accept as business records, again, both the GL claim worksheet and the police report or the EMS report, neither of which are business records. They're both prepared.
How is your records not a business record?
Because it's a claim prepared in anticipation of litigation, and it is an exception.
Hold it. It's not a business record. It's not a record that's ordinarily kept in the ordinary course of business. It's made contemporaneously, and it's a record that is routinely done as a matter of record. I mean, the three questions, I mean, I could look them up in the statute, but you're saying this does not satisfy the statutory three, what I call them, sometimes facetiously called the three magic questions. Your records don't satisfy that?
We'll say that it did. It's still hearsay within the business record. Just because it's in the business record exception does not mean that the statements contained therein are from the author. The author testified he did not see this incident happen. The statement contained in the incident report says what the plaintiff told him. And when the plaintiff is presented with that statement, the plaintiff says, I don't remember. So that's not.
But this is what a party is saying he was told. A party, an adverse party, your client is saying, this is what the plaintiff told me.
Right, exactly. It's not his own statement.
And now you're disputing it. And now you're saying that's not true.
Well, it's hearsay. It's what when I asked the plaintiff, how did you trip and fall? First of all, he says the business record is inaccurate insofar as it refers to hand knotted twine. So if it's inaccurate, I don't see why the plaintiff would be relying upon it. Secondly, even if it could be considered a business record, Your Honor, when the plaintiff is presented with that statement, he said, I don't remember how I tripped and fell. I don't remember. If it's in this business record and it is considered to be something that the plaintiff can withstand cross-examination, the plaintiff failed at that. The plaintiff could not say he didn't know what caused him to fall down. The plaintiff had the chance to tell Home Depot what happened at the time. He used
You're reporting that he did tell them at the time.
It's hearsay within hearsay. It's within the report. The plaintiff told in order for the business record exception to apply, Your Honor, the author has to be coming up with a statement in the record. For example, I reported to aisle 9 of the store. That's not what it says. The plaintiff is asking for the court to accept the statement of what the plaintiff reported to Mr. Regalia as fact for truth of the matter asserted. It's not Mr. Regalia's own statement. It is the plaintiff's statement. It is hearsay within hearsay, and it doesn't qualify.
Hold. Why do you keep saying hearsay within hearsay? The business record is not a hearsay. It may be hearsay within the business record, but it's not hearsay within hearsay if it's a business record.
Okay. The plaintiff cannot use a statement that he made that my representative, that Home Depot's representative quoted what Mr. Shurinsky reported to him. That cannot be submitted for the truth of the matter asserted.
Why not?
Because it is hearsay.
Why is it not an admission that that's what he said?
The incident report does not qualify under the business records exception because it was prepared when litigation was anticipated and not as Home Depot's daily operation, part of Home Depot's daily operations.
It is not part of Home Depot's daily operation to make incident reports whenever something of an incident happens.
That's not a daily operation.
I mean, you're
By comparison, an inspection report, that would be a daily operation. That is part of Home Depot's.
Where does business records say daily operation? It could be a monthly, it could be quarterly, it could be it's an incident report. It's in the course of business for them to make these reports. They do it ordinarily, regularly, they do it contemporaneously. Why does that not satisfy the statute, making it a business record? Whether the contents of it may or may not, I mean, I use the police reports as a typical example. Police reports, they're not in litigation business, but every time they're called out to a scene, they make a report. That's what they do. They do it in the ordinary course of business. Whether all of it comes in whether all of it's admissible, routinely, the answer is no, it doesn't all come in. It becomes an issue of, but it's not hearsay within hearsay, and it's not that it's not a business record. It's a business record because they do it in the ordinary course of business. They do it contemporaneously. It's part of their job to do it. That makes it a business record. I don't know why you keep saying hearsay and hearsay and that it's not a business record.
Because, Your Honor, I really don't mean to upset you on this point, but you just referred to police reports being partially hearsay. When a police officer, okay, I'm sorry.
I have no question about that.
Okay. Well, I mean, I've stated my position, Your Honor. When a police officer comes onto a scene and makes personal observations about the scene, he can be cross-examined by the other side about the contents of his observations as stated in the report. Mr. Regalia did not witness any part of this. He didn't witness the plaintiff fall. He didn't witness the plaintiff's foot hanging off the wire or anything of the sort. And he certainly did not have, he took exactly verbatim what the plaintiff told him on the date of the alleged incident and put that into the report. They're not his statements. They are the plaintiff's statements.
You're overly narrowly reading the concept of a business record. You're overly narrowly reading it. It does not have to be the report maker's personal observations. Absolutely not.
Well,
if you want to use the police record as an example, if somebody says, yes, I went through the red light, that is admissible. It's admissible against the person who said, yes, I went through the red light, even though the police officer didn't see it. It's an admission.
That's a different scenario. That would require.
But you keep saying that this particular author of the report didn't see it. You're overly narrowly reading the concept of a business record. You repeatedly are doing that.
Your Honor, I think that what you're referring to, again, is if you have somebody who is potentially ostensibly at fault for an accident, for example, and Mr. Regalia said, oh, this is a really dangerous condition over here that he probably tripped and fell over. That would be part of the business record. That is something that he observed on the scene. The plaintiff is attempting to use his own statement as a statement of a party opponent. It's not the statement of a party opponent. It's his own statement. And furthermore, to the extent that the plaintiff wishes to use what is contained in the incident report as evidence of what actually occurred, it sinks the plaintiff's case entirely because it refers to hand-knotted twine, which is not, as the plaintiff said, it was incorrect. So I don't understand the importance of the incident report at all. I mean, we're going to get to the trial of this case, and the plaintiff is going to have to get on the stand or, either perjure himself at trial or admit that he testified under oath.
Move on. Okay. All right. Move on. I think we've more than exhausted the business record issue. Unless that's the only point you have to make.
Your Honor, what I was trying to say was that when we get to the time of trial, the plaintiff is going to be put on the stand. And
I'm not concerned. That's not of interest to me for summary judgment.
It is of interest.
No, it's not of interest to me for summary judgment. The issue is whether today there is a material issue of fact. It's not a question of what the plaintiff will do or will have to do at the time of trial. I deal with right now, is there a material issue of fact? I don't deal with what the plaintiff will have to do. That there is inconsistencies in somebody's statement, that there are inconsistencies between what somebody said at the scene and what they say in an affidavit. All of those things are routine. The question is there a material issue of fact for purposes of summary judgment as of this morning?
No, there is not. And the reason there is not is what I was going to say, Your Honor, is when the plaintiff gets on the stand at trial, he will have to testify that he does not know, as a matter of fact, what caused him to fall. The last thing he remembers is standing on his feet. The next thing, he was on the ground. He does not remember which foot caught in what. He doesn't remember the direction that he fell.
You've gone through this already.
There's no inconsistency in the plaintiff's statements, Your Honor. The
Right,
plaintiff,
okay. Look, just tell me whatever else it is you think I need to focus on. I mean, we've covered this already.
you asked if there's any genuine issue as to any material fact about what caused the plaintiff to fall. And the answer is no. There is no genuine issue because the plaintiff does not know. Without that proof, I direct Your Honor to look at the 3 cases cited by Home Depot, which are very similar to this case, where there was something in the vicinity of what plaintiff suggested but did not know as a matter of fact caused them to fall, and summary judgment was entered in favor of the defendant. And in particular, the Kubera case, I think, is very similar. You're dealing with a store, you're dealing with something on the ground maybe that could have caused a trip and fall, but was not certain to have been the cause. And there is no genuine issue.
Again,
Okay,
I don't remember
you've
whether
interrupted me so many times. I gather that you probably want to
because
move
you keep repeating the same thing. You've said you've referred to those trial court decisions at least 3, 4, 5 times. When I was going to say, are you familiar with the Augustine versus CNAPS case, which was an appellate court case that attempted to say that distinguish those cases from other cases? So I mean, there is some criticism of those trial court decisions.
Yes, in the CNAPS case was cited by the plaintiff. This again involves a staircase and involves a heel getting caught on carpeting on the staircase. So again, while there may be criticism, there still is precedent for the position, and it is Connecticut law. I don't think Your Honor would disagree that it's Connecticut law that the plaintiff must prove each and every element of the claim. If you don't know what caused you to fall, you cannot prove your case. That's an essential element of negligence.
Right. Anything else?
Nope. Thank you, Your Honor.
Plaintiff's counsel?
Yes, if it please the court. Defendant's theory about when there is and when there isn't a genuine issue of material fact would largely eradicate probably 50% of the trip and fall and slip and fall cases that exist in Connecticut. The issue really is brought to a head by just how rare summary, as Your Honor knows, just how rare summary judgment is in negligence cases. Defendant has argued that plaintiff had every opportunity to tell his story. Defense counsel had every opportunity to ask appropriate questions during the deposition. The reason that I appended the entire transcript as an exhibit to plaintiff's objection to the motion for summary judgment is, I think, what the court will see when you actually read the Q&A that took place concerning the event on the day in question, July 3 of 2020, is that the defendant has truly manipulated and isolated discrete portions of responses to questions that really never asked specifically about germane issues on the fall incident itself. And what I've tried to do in our opposition papers is highlight the fact that you can't simply take out of context the Q&A. But I think the most fundamental point, and I think this is set forth in the Supreme Court's decision in Cole versus the City of New Haven, a 2020 case cited in our brief, citing the Senna versus American Medical Response case, is that the plaintiff really has no obligation to respond to a motion for summary judgment unless and until the defendant has eliminated all material issues of fact, in this case on the discrete issue of causation. Did the flat product cart, the orange cart with a pallet, wooden pallet, and a dangling wire that's depicted in the video and the still shots from the video, was that the cause of the trip and fall?
Oh, let's see. Show us, please. Please. I want to see it.
The defendant never asked the plaintiff in his deposition was, when you saw that wire, did it correspond with where you fell? And Mr. Regaglia in his deposition testified that both the plaintiff's body on the floor and that flat product cart were very close to one another, to the point where he, Mr. Regaglia, moved it out of the way when he got to the scene. And so I think that what's gone on here is perhaps not fully understanding the way that Connecticut courts deal with summary judgment and negligence cases, also not appreciating the fact that in many slip and fall cases, as Your Honor noted early on during the defendant's argument, the person who falls, if they had seen the hazard before the fall, they likely would have averted the fall. But having fallen, looking up to see what was I engaged with that caused me to fall, and the defendant tries to exploit the fact that she didn't ask the specific questions. Yet Mr. Regaglia noted in his form, in his report, in the business record report, the engagement with something that was dangling off of the cart. The Trumbull Police Department report reflects similarly, as does the EMS record. Now, I think that when the court actually reads that portion of the transcript, Your Honor will see that the defendant, despite vigorous protestation, never actually asked the questions that she would have needed to obtain negative responses from. And still, the fact that there were contemporaneous statements made to Regaglia, EMS, and the police department, as Your Honor notes, those issues about what's hearsay, what comes in, what can refresh the recollection, what questions could get asked at trial to lay out a consistent body of evidence from the plaintiff about what caused him to fall would be simple. But the back and forth between what was the milk cart structure or facility and what was the flat product cart was evidently confusing. It was confusing as I sat through this. It was confused. It wasn't confusing, as Your Honor will see when you read his testimony. And he says, no, I wasn't in a fixed position at that cart. And when I subsequently tripped and fell, and when I looked up after being on the ground, that's when I saw the wire. So I think that the defendant has not established that there is no genuine issue of fact. The Q&A and the deposition doesn't suffice. This isn't a situation where the plaintiff said, I don't know what happened. He may not know which foot was the first to cause the trip, but that's not a sine qua non. That's not necessary to prove his case that he tripped over the wire. And there it is. I think there's clearly a contested issue, a genuine issue of disputed fact with regard to causation, how the fall occurred. I think that Mr. Regaglia fairly assumed that what he was being told was correct. Mr. Regaglia, in fact, testified that it was a Home Depot associate working with a vendor at Home Depot that had placed that cart in the middle of the millwork aisle to begin with. And I don't think that there's a notice issue under the Tuitt versus Stop and Shop case. And I think that this is clearly a case where summary judgment should not be entered. Thank you.
All right, any response by the defendant?
Sorry, Your Honor, the plaintiff's counsel repeatedly suggests that my questioning of his client was confusing. The complaint references the orange dolly as the instrumentality of the thing that had the wire hanging off of it. And indeed, Mr. Casper referred to the orange dolly as the thing with the wire hanging off of it during his argument to you. The plaintiff's own complaint alleges that the orange dolly was the object that had the wire hanging down off of it. The plaintiff in this case did have ample opportunity to testify about what happened, and he said that I don't know what I fell on. That's what he said. He said, I don't know. I don't remember. So it's kind of like, I guess, but there because I don't remember that. That's what his testimony was. But all I remember is hitting my butt, and I remember going back. I asked him to describe exactly how it is that he ended up on the ground. He could not tell me. I asked him a number of different ways after sorting through the difference in the allegations in the complaint to what he was telling me at his deposition. He says he does not know what happened. He says, I must have backed up. I'm assuming I got caught on that. Assuming and must have and could have or an inference is not sufficient under Connecticut law. And I'm thoroughly familiar with how to file and prevail on summary judgment claims in Connecticut. I have been practicing in Connecticut since 2009. So I respectfully disagree with Attorney Casper that I'm unclear of how summary judgment motions are handled in Connecticut. When the plaintiff testifies, quote, I didn't know what I fell on. That means he doesn't know what he fell on. It could not be any more clear than that. And when he is standing there with his medical expert who is paid to testify for him, and he doesn't say that he caught his foot on a wire, and he tells his own expert, I don't remember how I fell down. I don't remember. I just remember being on my feet and then I'm on my ass, as he said. I don't know what is more compelling than that. He has every reason in the world to say, I fell on the wire. I tripped on the wire. Here's the picture of the wire. This is the thing I tripped over. He didn't say that to his own testifying expert. So again, there is no genuine issue as to any material fact. The evidence is not going to change from today to the time of trial insofar as what caused the plaintiff to trip and fall. He's made it abundantly clear. He does not remember. And because he does not remember, and where there are no corroborating witnesses, there's no CCTV, there's no objective evidence of how this happened. It's not like his foot was hanging in the wire as he's lying on the ground. We don't know what caused him to fall down. He doesn't know what caused him to fall down. So when I was saying to Your Honor, when he gets to the time of trial and he's asked on the stand, what caused you to fall down? He's going to say, I don't know. And that's where we are today. And you know, you referenced the trial court decisions where summary judgment was entered. They were not appealed and they were not overturned on appeal. They remain good law in Connecticut. And while they may be distinguished by other appellate court cases or other cases with different facts scenarios, they're very similar to this case. And, you know, we submit that summary judgment should enter for Home Depot. There is no genuine issue as to any material fact. The plaintiff cannot prove causation.
Well, just on that last point, though, I mean, trial court decisions are not binding on me. And on occasion, I agree with other trial court cases, and on other occasions, I disagree. And I have, in fact, in front of me one matter where I very, very much disagree with something that was done by some other trial court decisions. And my only question is whether I'm going to write a formal opinion or just simply disagree. But the point is, the fact that trial court decisions go unappealed and may conflict with my interpretation doesn't mean that I am in any way wrong. Ultimately, it becomes a matter of, if necessary, an appellate court deciding it. But I mean, it's a basis on which I could follow some approach to the law, but the fact that trial court decisions may go in a particular direction is, you know, in no way, shape, or form binding on me. It is simply something that I need to consider out of fairness, because sometimes other judges have it right and I have it wrong, and maybe they'll illuminate me why I'm wrong about things. But it's not binding, and that's why I primarily look to appellate and Supreme Court decisions, because those are, in fact, literally binding on me.
Right. And when I guess Taking that further, Your Honor, the Supreme Court and the appellate court decisions say that in order to make an inference, there has to be some foundation. There has to be evidence of something having caused a trip and fall, not just, I think it might have been this. That is not evidence. There is no evidence that this is what caused him to fall. You're allowed to make an inference when the staircase is unlit, the treads are uneven, and someone is found at the bottom of the staircase, that perhaps this, combination of issues could have caused this to happen, and for that reason, there isn't genuine issues of material fact.
If he came out right now, or however, I don't know how long this has been going on for, but after having said, I don't know what caused me to fall, I don't know what caused me to fall, if his expert asked him and he said, I tripped on the wire, tell me she wouldn't eat him for dinner on the stand. Tell me that she would not take that as an opportunity to be like, were you lying then or are you lying now? Come on. The man says he doesn't know what caused him to fall, but the wire was there and he thinks that that's what happened. She would completely destroy him on the stand if he flipped his story.
Jury should hear about. There is no such foundational evidence in this case. The plaintiff himself says, I was on my feet and then I'm on the ground. I don't know how I got to the ground. I assume I must have tripped.
But that simply goes back to the issue of often a plaintiff is incapable of answering those questions because of amnesia, because of death, or whatever it is. So that's the fact that the plaintiff himself is not able to answer the question, may have a memory deficit from a concussion, all kinds of things. I mean, that is a factor, but it's not determining the fact that the plaintiff himself cannot give that answer, is it?
No, it's not. But I'm just saying that there's no foundational evidence to support an inference of the type the plaintiff's counsel is asking the court to make here. And the decisions that Your Honor is willing to accept and to follow as precedent say that there has to be foundational factual evidence that would support the inference. And there is none here.
All right. Well, that's ultimately what I'll have to decide. It looks like plaintiff's counsel wants to get something in. So before we wrap up, because we're running out of time, anything further that plaintiff's counsel wanted to say? It looked like you're anxious to say, get something in.
It is difficult to distinguish the claim that there is no evidence from which to draw an inference when there's clearly a dangling wire that's depicted in the photographs, and there is discussion in the records of the dangling wire. And it's also important, I think, Your Honor, just on a from a factual standpoint, counsel for the defendant has asserted once again that she has interpreted the allegation in the complaint about the dolly with the dangling wire as being the equipment that Home Depot stations for self-service cutting of measured millwork. I don't know that facility, that self-service station, is properly called a dolly, but clearly the flat product dolly, which is also orange and had the dangling wire, that was present at the scene that Mr. Regaglia investigated and is depicted in the video and the still shots from the video, is clearly a dolly, because I have no idea what else that would be called.
All right, I will take the papers on this. Thank you all, and I apologize if I stepped on anyone's toes, but I try to focus as best I can on what I see as the real issues, and unfortunately sometimes that involves seemingly stepping on toes. So I apologize if I came on too strong on that, but in any event, I will take the papers. Thank you all. Have a pleasant, productive rest of your day, everybody. Take care, and we can go off the record at this point.
Thank you.
Thank you.
Thank you.
Oh no, we don't even get to know the outcome. I'm sorry. It's not my fault. It's not my fault. It just means that we get to make our own determinations of what we think the outcome is. I don't know. They were all coming in hot and heavy, so I don't know why he thinks he needs to apologize for it. Oh boy. Is he? He's on the ballot? Oh, I didn't know. Barbie is going to make a full report in a week. She's going to be like, I found it. They all were pretty passionate. Well, Mr. Casper was kind of sleepy, but he didn't need to say much. If you know what I mean. Okay. I don't know. I've not tried that tactic yet. Well, I'm really glad that I got you guys hooked on it. Hearsay within hearsay. I loved that part. I heard that was one of my, oh yeah, I got her on this one, lines that I came across as I was thumbing through it. Oh, my cheeks hurt from laughing so much. Oh, you guys. All right. Excuse me. I got less sleep than what I streamed last night. Yeah. So I'm going to go to bed tonight. I already got my shower in. My hair's still wet. It'll dry. Excuse me. Yep. It's definitely bedtime. Oh, I love you so much. She wants to know the names of all the parties involved because she wants to investigate what the outcome of the judge's ruling is. She's invested in the case now and she wants to know. Good night. Okay, I gotta quit this. I'm sorry. I love you guys so much. Thank you for coming and hanging out with me. As always, that was so much fun. Be safe, be well, sleep sweet, and much love.